All right, we are live here. Oh, okay, that's me. Yep, there you go. All right, so this is Chris Berry, certified outlaw attorney, certified financial planner with Castle Wealth Group. We do these legal, financial, tax planning workshops every week. We call them a wisdom webinar, where we're just answering clients' questions or questions submitted from the public, either via email ahead of time or live while we're on the webinar. I always like to start with a positive focus, just something positive that's happened over the last week or so. A couple things. One, my son, who's 15, he is on the swim team. He's in 10th grade, and he's also in marching band. And right now, marching band's not really going on. That's in the fall, but they are right now on the road from Michigan, heading down to Florida. They're going to be uh, marching and performing at Disney World, so that's kind of cool. But he's also on swim team, and so I had to get him to yesterday. I had to get him to because he can't drive yet. He's only 15, to swim practice at 5:15 in the morning. Then he had school. He had swim practice afterwards. I had to pick him up. We ate dinner. I had to get him his last minute stuff because he didn't pack very well. I had to drop him off at marching band at 7, pick him up at 9. And then today we had to get him to the bus to go down to Florida at 6:40. Long story short, I'm proud of him. I can't wait until he's 16 and he can drive himself. And then the other positive focus, just professionally, we've moved into our new office in Brighton. We've doubled our space. I've worked on my office, so that's my son. There's a marching band picture somewhere. I lost it. Yep. Oh, right there. Yep. Um, but yeah, just getting some stuff done in the office. I have some pictures there. And then, yeah, coaching my daughter in soccer, indoor soccer right there. It's going to be shortly. So it's fun to be able to point to those pictures. But all right, enough about it. Let's get into the questions. All right, so I had 3 questions submitted ahead of time. If you do have a question, feel free to put it in the legal or put it into the Q&A. All right, give me a second. Yeah. All right. Here's a question. Oh, already dealt with that one. I'm sorry. Give me a second. There you go. All right. So question is, and this is with regards to Medicaid, which can pay for nursing home care. So the question is, um, we have our assets in a Castle Trust for over 5 years. So our investments are sheltered from a Medicaid spend down. We have monthly income from pensions and Social Security. I'm not going to get into the exact amounts, but yeah, so there's assets and then there's income. And the question is, are our pension and Social Security income subject to Medicaid? Okay. So the first thing I would say is understand the only type of trust that protects against nursing home or Medicaid spend down would be what's called a Castle Trust. We call it a Castle Trust. It's an asset protection trust. So the first thing is make sure you actually have a asset protection trust versus just a basic revocable living trust. And there's a lot of people, I'm not saying it's you or anyone on this call, but there's a lot of people that don't understand the differences or the complexities. In fact, I just got off a call with one of my team members, and we did some planning for the parents, and we set up an asset protection trust that's going to protect against that $10,000 to $15,000 a month nursing home bill. And the son, who's an attorney, but he does a completely different other area of law. He said that like what we did was a little more expensive than other estate planning attorneys that he talked to. And so that's where understand that like we need to make sure we're comparing apples to apples versus apples to oranges. Because if at the end of the day we're just trying to avoid probate and make sure stuff goes where it's supposed to, then yeah, maybe we'd do a revocable living trust. But if we are concerned about that $10,000 to $15,000 a month nursing home bill, which especially in this situation, one of the spouses had Parkinson's, so obviously long-term care was a huge concern. And if we can spend a little bit extra money to protect against that $15,000 a month nursing home or Medicaid spend down, then that's probably a good investment. So I'd say the first thing is make sure that we actually do have an asset protection trust. Because especially when I do a lot of these workshops, people assume that if they have any type of trust, they're starting that 5-year clock for Medicaid purposes. Um, so understand, it has to be a asset protection trust, not just a basic revocable trust. And that's why it's important to work with a certified elder law attorney, a CELA. And again, there's only about 15 of us in the state of Michigan. Anyone can say they do estate planning or elder law, but unless they're a CELA, they might not know exactly what they're talking about. So that's first thing. So understand that the way Medicaid works, so Medicaid is a governmental program that will pay for nursing home care. But to qualify for Medicaid, there is an asset test, not an income test, an asset test. And for a married couple, if one spouse needs nursing home care, the other spouse is healthy, at most that healthy spouse can keep $160,000 of countable assets. Basically everything other than a home, prepaid funeral, small cash value of life insurance, automobile, and personal possessions. Everything else is a countable asset. Uh, and then a single individual can only have $10,000 worth of countable assets. So a married couple, one spouse in the nursing home, healthy spouse can keep up to 160. Single individual or widow can only have $10,000 worth of countable assets. And then Medicaid looks back 5 years to see if you moved any assets around. So with the Castle Trust, the Asset Protection Trust, what we're trying to do is move assets into the trust and then try to make it the 5 years before we need nursing home care. But the question is really about the income. What happens to Social Security and pension? So with that, typically that income, at least a portion of it, is going to go to what's called a patient pay amount. So typically what's going to happen is if someone needs nursing home care, they're going to take the income from Social Security and pension. They'll allow the person who needs the care to keep up to about um, they're going to take all of the income less about $60 a month. If it's a married couple, there is a calculation that goes into it. But think of it as basically they're going to take most of the income. And so that's why it's so important that we set up the asset protection trust to protect the assets. A, to make sure the person who needs care has this pot of resources to improve their quality of life. And then B, especially with a married couple, we want to make sure that that healthy spouse isn't completely impoverished having to pay for the care. Okay. So again, this is a complicated area. Not just like you start going into the phone book or Googling, you might not find certified law attorneys that know this like the back of their hand. So you're going to hear all kinds of different things. So hopefully that's helpful. All right. Let me see what else we had. All right, give me a second. I had them ready. I lost that. All right, here's another question. All right. So this question, let me see. And again, if you do have a legal, financial, tax planning question, feel free to put in the Q&A. All right. So here's a question again. It's about Medicaid. Does the new $15 million exemption actually protect my house from Medicaid recovery, or is that a myth? Okay. So with this, we're actually looking at two different things. So the $15 million tax exemption, I assume what we're referring to is the current estate tax exemption, or death tax or inheritance tax. So a single individual can leave $15 million to the next generation estate tax free, meaning they don't have to pay any inheritance tax. This used to be as low as 600,000, but in the 20 years of my practicing law and doing financial planning, it's went from like 600,000 to a million and a half, 3 million, 3.5 million, 5 million, 10 million. Now it's 15 and $30 million. 15 for a single individual, $30 million for a married couple. So as long as you die with less than that amount, you owe zero in estate taxes. Um, so we do have some clients that are in that range, and so there is planning that we have to do. But to be honest, for a majority of people, like they don't have 15 to $30 million. So don't worry about the estate tax, not an issue. But now what we're saying is, okay, we have this estate tax and then we have Medicaid recovery. So two different two different programs completely. Um, and that's why our asset protection trust, our castle trust works so well is we're not protecting against estate taxes where you have to give up control. What we're protecting against is like Medicaid and Medicaid recovery, where you can still have a lot of control. So here's the thing with Medicaid recovery, the way it works is I talked about the rules to qualify for Medicaid. A single individual can have 10,000, married couple, 160,000 accountable assets. Everything other than a home, prepaid funeral, cash value of life insurance, automobile, personal possessions, all of those are countable assets. Um, and then Medicaid has a 5-year look back period. So I do see people combine like tax laws with Medicaid rules. They work completely different. And so and then here's the other thing with Medicaid, since 2014, Michigan passed what's called a state recovery, where now you can be qualified for Medicaid while you're alive, but upon death, whatever Medicaid paid out in benefits, they can place a lien on your assets. Here's the trick to avoid a state recovery in Michigan is that we need to make sure everything avoids probate because they can only place a lien on the assets that end up in probate. So as long as we avoid probate with all the assets, we avoid that estate recovery. And the big thing that ends up in probate is the house. So that's why a lot of times we do what's called a ladybird deed. Ladybird deed. Named after Lady Bird Johnson, but it's the type of deed that says the home is in your name while you're alive and well. Then upon death, it flows to your trust or your beneficiaries. So I actually just got off a call right before this webinar. They live down in Arizona. Mom lived in Detroit. She has a house. Dad passed away. Mom has cancer. She moved down to Arizona to stay with her daughter. But there's a concern if mom needs long-term care or nursing home, we want to make sure the home goes to one of the kids. So that's where we're going to set up what's called a ladybird deed, a type of deed that says the home's in their name are alive and well, and then upon death, it goes to the beneficiary and avoids the estate recovery. So again, whenever you're talking about long-term care costs, that's where you don't want to just work with an estate planning attorney. You want to work with an elder law attorney, maybe a certified financial planner, because again, like all these pieces are connected. And so yeah, the question was about estate taxes and Medicaid. Um, both are concerns, but they have different rules. So that's where we need to be cognizant that um, depending on what our goals are, we need to follow different rules. So uh, hopefully that was helpful. All right, let's see what else we have. And again, if you do have legal, financial, tax planning question, feel free to put it in the Q&A. I think I have one more. I just gotta track that down. Give me just a second. I'm sorry. I know I had one more. Oh, I lost it in my email. Give me a second. Hold on. Oh, here you go. Yep. Um, this was from you, Mike. And then again, if this is the last one I have, it, if there is something that I didn't cover and you emailed it over, feel free to put it in the Q&A right now. I'm just trying to catch up on these. All right. So here's the question. Do married couples need durable power of attorney and advanced directive slash medical power of attorney, or can the spouse make these decisions without them? Okay. So here's the big thing. So we have what we call disability documents, and there's two key disability documents that everyone over the age of 18 needs to have in place. One is a financial power of attorney, the other is a medical power of attorney. In Michigan, we call that a patient advocate designation. You might also hear it called advanced directive or healthcare proxy or living will. But in reality, there's two documents that anyone over the age of 18 needs to have in place: financial and medical power of attorney. So the question is, do married couples need to have these documents in place? And the answer is a definitive yes. Okay, for sure. So it is a common misconception that you can automatically make these decisions for your spouse. But that's not the case. And we see this both on the financial as well as the medical side of things. For example, let's say you have an IRA that has to be in your name. IRA cannot be joint. IRA has to be in your name. You can name your spouse as a beneficiary, but the IRA has to be in your name. God forbid you have a stroke, you're unable to take care of things. Your spouse cannot call in to get any information on that IRA if you're incapacitated. They can't ask about required minimum distributions. They can't ask for an additional distribution because it's only in your name. The only way that your spouse can access that would be if you have a power of attorney or you pass away, because it's just in your name. Um, I had a situation in my practice a number of years ago. We had husband and wife. Wife had dementia, didn't even recognize husband at this point. She was in assisted living with memory care. Husband and wife had a property up north. They were joint on it. He wanted to sell that property to help pay for her assisted living, but because they didn't have any documents in place, he could not sign for her. And so we had to go get a guardianship over her. Where now a court would approve the husband to sign the document to be able to sell that property. And then the common scenario is the Terry Schiavo situation. She was a woman down in Florida about 30 years ago, like 1994 or so. She was married. She was in a vegetative state. Her husband wanted to remove her from life support. Her family wanted her to remain in life support. It became a big court battle. It lasted over 8 years, and made it all the way up to the United States Supreme Court. So again, a big takeaway is anyone over the age of 18 needs to have a financial and medical power of attorney. Your spouse does not automatically have the ability to make financial decisions or medical decisions. It has to be in writing. Now, where people get hung up is they're like, oh, but I can do stuff at the bank. Well, if it's a joint account, either one of you can do things. But understand, not all of your stuff is joint, like especially your retirement accounts, like your IRAs, your 401ks, your Roth IRAs, those are in individual names. And then even like your real estate, like we need both signatures if we want to sell a property up north. So it it's super easy, not expensive. Everyone over the age of 18 should have a financial medical power of attorney. So, all right. That was all I had in terms of pre-submitted questions. So if you do have another question, I'm gonna log off here, but feel free to put in the Q&A. So with that, thank you, everyone. Take care.